that evidence in?
Very well, better than I think I am sitting in the courtroom. They are taking notes, leaning into the evidence, turning to the screen, and with the booklets, that seems to be beneficial to this jury as they study the photos up close. I don't see them nodding off in the afternoon. The defendant, like I mentioned earlier, seemed to be nodding off, but again, he is unwell. The gallery today full. More full than usual with family members of Bart and Krista Halderson, particularly Bart's brother, Brett, who had testified in this case, sitting there again today all day.
All right, well, Chanley Painter, thank you so much for that report, and please stay safe out there. Go take your get off the set, put your mask back on. We don't certainly want you catching anything that might be going around out there. All right, let me bring in my guest for this hour. Joining me now, former Department of Justice senior attorney and former federal prosecutor Tammy Allison. Tammy, great to see you. Thanks for being on the show tonight. I do want to wish you a happy New Year.
Happy New Year, Michael. Thank you for having me.
All right, great to have you on the show. Let's start off by just talking about this case in general. As a former prosecutor, watching this prosecution work, the mounds and mounds of evidence they have, your thoughts on the case that they've been presenting thus far?
I think the prosecution is doing a great job, Michael. The fact that there's so much at play here, not only the fire, but the exit wounds that we heard from the individual who conducted the autopsy, from a firearm, the gunshots. It's very gruesome, and it's important for the prosecution to take their time to connect the dots for the jury, and as we like to say here, make it make sense so that when they present their arguments, the jury can find beyond a reasonable doubt that this defendant is in fact guilty. I am curious to see how the defense is going to combat against this very strong evidence against the defendant.
Yeah, I don't know. I mean, I wanted to ask you about that. You know, there've been some cross-examinations. Some of my guests have termed it surgical. They're going in, they have usually 3 or 4 questions. They're trying to nitpick certain things that you can sort of check the idea that they're going to check those things off when they make their closing argument. They've basically gone the reasonable doubt route. Your thoughts on a possible defense here? I mean, if you were representing this guy, not sure where else they could go.
You know, Michael, I think the best thing that the defense can do with these types of cases where the evidence is so strong is, like you said, to attack the reasonable doubt and the fact that that is the standard here that the prosecution has to meet. And that's a very high burden, just to remind our viewers. Beyond a reasonable doubt is what the jury has to find in order for this defendant to be convicted, to be found guilty. So the defense is just going to poke holes in the evidence that's presented, whereas sometimes we see defense counsel ask more leading questions to direct the attention to the jury elsewhere if in fact the evidence is not as strong, maybe to point out some types of circumstantial evidence, something that isn't as tangible as the evidence that we have here in this case.
Yeah, it's extremely tangible. That's a great word for it. There was a little tidbit today, I just asked Chanley about it, that I thought perhaps could be a little ray of hope, a little tidbit for the defense. You know, they were talking about the items used to dismember the body. They were talking about DNA found in and around the home. They had some on the fireplace. They had some on some shoes. He lived in the house. Those things, that wouldn't be odd. You could make the argument that doesn't really mean anything. But they didn't find any on the actual items used to, let's say, dismember the body, right? So now we don't know about the gun yet. I'm sure they're going to bring that evidence out later if they have it. But that's something, for instance, that the defense could argue in closing, saying, hey, look, you know, they could find this stuff in the house, the DNA on the fireplace, and of course in shoes, but it's not on the main things used to dismember the body. That's the type of thing that you can use to maybe build some blocks for reasonable doubt, no?
Yes, absolutely, Michael. That is what they could do. But at the same time, if the prosecution plays their cards right, they're going to be like, well, who in their right mind is all up on a fireplace whenever we have bodies that were burned in that said fireplace? Any person who is avoiding trying to get caught, they're going to probably clean the weapons that were used to dismember the individuals that they're killing. So I don't think that it's that far-fetched to say that there's no DNA on the tools used to dismember the bodies. But yes, the individual did live in the house, so it's not uncommon for DNA to be found within the house up and through it. But that fireplace is very strong. And if the prosecution, again, goes ahead and lays out all of the evidence they have without missing any little bit, just because they have strong evidence elsewhere, it doesn't mean that they should not present some of the weaker evidence that they have as well in order to pile on so that they can reach that very high burden of beyond a reasonable doubt.
Yeah, I'm glad you mentioned that, because that was the next thing I was going to get to, the fact that there is so much evidence for the prosecution. Some of it, like today, they had an expert on who wanted to make sure that they understood by video analysis that there was a fire burning in the Halderson home. Seemed like a lot of time and expense for something that was a real small part of the puzzle here. There were so many other things that are much stronger. But I think it's important to note the point that you make, that even the weaker evidence, prosecutors don't want to make any missteps here. You bring it all in. If it takes 3 weeks, a case that looks like a slam dunk, then it takes 3 weeks, right?
Absolutely, because we've seen defense counsel pounce on those types of things whenever prosecutors get a little too cocky, like, okay, my evidence is so strong, but the defense can go and poke holes at some of those weaker arguments, and the jury pays attention to everything. So it's very important that the prosecution, no matter what case it is, to present all of the evidence. Maybe not spend so much time on some of those weaker arguments, but all of it is important so that the defense cannot poke holes and they can prove beyond a reasonable doubt.
All right, and you heard we also have a case of COVID-19. The defendant has tested positive for COVID-19. There'll be a hearing tomorrow morning. In your mind, what will go on in that hearing, and what are some of the possibilities that could come of it?
You know what, Michael, at this point, given the CDC guidelines, who knows what's going to happen? They might just be like, we all going to catch it eventually, or they may go virtual. I'm not sure what's going to happen with the hearing, but, the defendant has a right to, feel well and get his health looked at and checked out. But at the same time, not only does the defendant have a constitutional right to a speedy trial, the public at large has that right as well. So I don't know if the judge is going to delay the trial or postpone it for a later date, which could be, in some situations, months or years.
Yeah, we'll find out tomorrow morning what's going to come of this breaking news. All right, Tammy, stand by. We're going to take a break right now. When we come back, new charges for the case in the stepmom of a little girl in New Hampshire. Why prosecutors dropped 1 count and then added 9 others. And then later in our Talkback segment, if you remember, Judge Bruce Schrader in the Kyle Rittenhouse trial ruled that the state couldn't refer to any of the men killed or injured by Rittenhouse as victims, in part because it was a self-defense case. Yesterday, the judge in our next live trial, Wisconsin versus Edgecombe, delivered the exact opposite ruling in a self-defense case, allowing the state to use the word victim if they so choose. So we asked our viewers, in the case of self-defense, should prosecutors be allowed to use the term victim, or is it too prejudicial? Let us know what you think, and we'll share some of your comments later on in the show. Keep it right here on Court TV. Prosecutors plan to drop a welfare fraud charge against the stepmother of a missing 7-year-old from New Hampshire. However, they plan to replace the charge drop with 9 others, including theft. The Attorney General's office said the change was being made based on new information provided by the State Department of Health and Human Services. Last week, Kayla Montgomery pleaded not guilty to welfare fraud after being charged on suspicion of obtaining $1,500 in food stamps from December 2019 to June 2021 for Harmony Montgomery, even though the girl was not living with Kayla and her then husband, Harmony's father, Adam Montgomery. In an interview with police on New Year's Eve, Kayla Montgomery said she last saw Harmony on November or December of 2019 when she and Kayla's father allegedly dropped off Harmony with her mother. The little girl has not been seen since and was not reported missing until late last year. Harmony's great uncle started a fundraising effort. Police are still requesting help from the public in locating Harmony. Anyone with information can call 603-203-6060. He said, and also Manchester police have said that the reward for information that helps find Harmony has actually grown to $94,000. What else is interesting? They also went to the property where they used to live. They no longer live there. New family lives there. No connection to the case at all. And they searched for over 2 days, digging up the backyard, did all kinds of things. And right now, we don't know what the result of that search was. Investigators are keeping that close to the vest, but we'll continue to check, and anything that comes out, we'll let you know. Let me bring back in my guest, former Department of Justice senior attorney and former federal prosecutor, Tammy Allison. Tammy, we got 3 people in this case, right? We got the mom, who seems like she's in bad shape. She's got drug issues, right? She couldn't get custody of the child. She gave it to the father, who's a batterer. Basically, he's facing charges of hitting the little girl. We got the welfare fraud with the stepmom. So we got three people who probably one of them knows what happened. How do you think this case gets resolved?
You know, Michael, in these types of cases, it could go any way. I think we've seen time and time again, whenever children are involved and they're missing, that sometimes the facts of the missing child will go in a completely different direction than what we're thinking of. We all recall the case of Casey Anthony and what happened in that situation. So I'm not sure what's going to happen in this case. I pray for the safe return of this child. But at the end of the day, with so many adults involved and each one of them having their own individual issues, I wish that Child Protective Services or police or someone would have intervened, because it sounds like the factual circumstances surrounding each one of these adults was strong enough to possibly prevent the disappearance of this child.
You know, I saw an interview with someone at Child Services out there in New Hampshire, and they were saying that they did indeed have contact with the family. They did, in fact, get some calls about that family, various things, some of them involving child welfare, et cetera. But they found everyone to be healthy and whatever. And once that contact begins to recede, they really don't have that responsibility because they can't know what's going on. That was his claim. So, you know, we can quibble with that, and I certainly do quibble with it at the end of the day, but it really was the responsibility of these folks. Now, you're a former federal prosecutor. You have folks, you got father in custody, you got the stepmom in custody. Mom's not in custody, but certainly you can find a way. How do you lean on these people? What do you do to lean on these folks to try to get information from them? Because again, I find it hard to believe that one of those three don't know what happened here.
Exactly. You know, the way to lean on these individuals is what the prosecution has done. You know, finding the charges against each one of these individuals that doesn't necessarily have to do with the disappearance of the child, right? So they are now facing charges not necessarily directly related to this child, but some of their individual issues, as we've heard with the child welfare fraud. That in and of itself is going to allow that individual to think twice before lying about anything that she knows or doesn't know about the missing child. And if she does have information about whether it's directly involving herself or someone else, she's going to be more likely to speak up because she's facing those charges.
Yeah, that's would be the hope, right? That they're facing these charges, you get them in custody, put pressure on them, and somehow they decide to tell a little bit more of what they know. But here's the other problem with this case, Tammy, that really makes it heartbreaking, is the idea that it took 2 years for folks to figure out this little girl was missing. So, you know, that in and of itself is something you have to look closely at and definitely mourn that idea. But also, that puts investigators 2 years behind in a case like this. As I said, they went and searched the house where the little girl was living with these two, and somebody else lives there. It's a whole new house, all different things going on. So just talk about some of the difficulties in backtracking on a case that's now 2 years old.
Ooh, Michael, I can go on this topic for a long time, but we have to understand that these are employees of the government, okay? They are severely overworked and underpaid. How many times do we have to see a situation like this where CPS is involved, they have had contact, and then a child either ends up dead or disappears? We need to take a closer look at these government employees that are overworked and underpaid so that they can pay more attention, follow up with the leads, and hopefully we can start seeing a change in lives of these young children being saved. And unfortunately, sometimes, you know, some of these government workers that are overworked and underpaid seem to pursue issues that are not factors, that are very minor in comparison. In this situation here, in retrospect, yes, it looks like there's a lot going on, especially with all of these adults. 2 years back, that is a lot of paperwork and a lot of transition in employees that have been in and out. So hopefully they maintain their files for the sake of this child so that there can be justice.
Yeah, absolutely, because that's all anyone wants. They want to hopefully find her alive. There's still that slim hope that she's out there. They may have gave her away, sold her. She might have wandered off. Somebody's taking care of her. You got to hope for the best there. But at the end of the day, like you said, you're always hearing about these overworked departments. It's always caseload, caseload, caseload. There's just too many cases. Got to figure something out here to keep these kids safe. All right, Tammy, stand by. When we come back, we have new developments in the Alex Murdaugh case. Now, that's coming out of South Carolina. You guys know the story. We have updates for you. You don't want to miss it. This thing's getting crazier and crazier. So keep it right here on Court TV, your front row seat to justice.
The guy sitting in front of you in the jail with the mask on is the only one who's charged with anything. He's not Don Corleone. There's not some mafia family out there. If there is, then I challenge Mr. Waters to indict him.
Welcome back to Court TV Live. I'm Michael Ayala. We have new developments in the Alex Murdaugh mystery coming out of South Carolina. The once prominent lawyer had a bond hearing yesterday. Now, his attorneys argued that he had less than $10,000 in his bank account. This is a multi-million-dollar family. And that he's not charged with a violent offense, saying, quote, he has a constitutional right to be released on bail and in an amount no higher than necessary to ensure his presence at trial. Now, presiding Judge Allison Renee Lee said she would issue a written order in the coming days. Now, back in December, Murdaugh's bond was set at $7 million with no option to pay 10%. Normally, you pay 10%, still be $700,000 to get out, but that's not that available in this case. During yesterday's virtual court hearing, Murdaugh's defense team suggested their client is devoid of assets and cannot even pay his phone bill, let alone a $7 million bond. One of Murdaugh's alleged victims, Thomas Moore, a member of the South Carolina Highway Patrol, that's right, an officer was one of his victims, spoke during the hearing.
You know, I've been in law enforcement almost 25 years. I've been to a lot of bond hearings, some of them minor, some of them major. Everybody's entitled to a bond hearing, and everybody's entitled to a bond to be considered. That doesn't mean they're entitled to a bond. And the bond doesn't have to be what they can afford it to be. It needs to fit the crime. I know Mr. Murdaugh as my attorney. I was asked to go to him because he was a good attorney. Very nice man. Always very nice to me, very cordial. Never had any issues. Communicated with him on a regular basis. But here's the problem. He treated me that nice, and he stole every dime I had from the injury I incurred.
I could listen to Officer Moore all day. Still with me, former Department of Justice Senior Attorney and former federal prosecutor Tammy Allison. Tammy, you know, the big question there was raised by the officer there. The idea is that the punishment should fit the crime, the bond should fit the crime, and that's what the defense is claiming here. It doesn't quite fit the crime. $7 million for basically a non-violent crime. Now, the state was only asking for 6.2 because that's the amount that he's alleged to have stolen from various folks, including Thomas Moore there. So your thoughts on that $7 million bond?
You know what, Michael? Perhaps the judge was taking a lot of other things into consideration because this is a very complicated case that goes way back with the murders of his wife, his son, and giving money to his other son and the law firm and the attempted murder of himself where he hired someone but he didn't die. So I think that he might, pose a risk to himself or to the community, as the judge has stated. And unfortunately, in these types of situations, we see bonds set this high where they know that a defendant is not going to be able to afford it because of the fact that their resources are drained by paying for legal representation. It's not necessarily right, but this is something that's common in the criminal justice system that we see, which is part of the reason why we call for reform. So this white man is starting to see some of that bias that we've been talking about when we talk about the need for criminal justice reform. But at the same time, he did a lot of stuff here, and it's shaky. So I'm interested in seeing how it plays out.
Yeah, last check, he's got 8 open criminal investigations in addition. Now, no charges yet. He's got criminal investigations. And the arguments made by basically the state was that he's not only a danger to himself, but also to the community for exactly the reasons you mentioned. He hired someone to shoot him, to kill him, so that his family could get his insurance. So, just the fact that you have someone shooting at you, all the people around could, somebody could be hurt. The other thing was, even though he doesn't have any money, it's all about access, right? We know that. He has access to money. His father died in June. He stands to inherit millions from the father. So he could go to anyone and say, hey, lend me some money. I'll pay you when I get my inheritance. Here's what the inheritance looks like. It's substantial. So, I agree with you. I think the judge certainly went in the right direction here.
Absolutely. There's so much going on here. And even though, like you said, there aren't charges yet, there's so much going on. So much. And I think the judge is also looking at this man like, this is a whole lawyer, okay? Very well-respected family, very highly respected attorney, allegations of very egregious things that he's done, but these charges that are before the court in this situation where his bond is set at $7 million, they're still very egregious charges. To think that someone who has an ethical and a moral obligation as an attorney is possible of behaving this type of way, it's very important that the judge takes that part into consideration as well, given his profession and the fact that essentially this charge here seems to indicate that he used his position of power, not only in the community, not only his financial position, but his position as an attorney to take advantage of his victims. And that might be part of the reason why the judge set the bond so high.
Yeah, we heard earlier from Thomas More. I want to hear a little bit more from him because exactly right. What you're saying is that even though the crimes are financial, not violent, they are serious and people were seriously hurt by it. Listen to some more from Thomas More here.
If he didn't have money, like some people are saying, and there's so many questions about money, how does he have all these attorneys? These attorneys I've seen on TV and in the newspaper, but I couldn't afford to hire them. So how can he, if he don't have any money? If we're going to talk about money, let's talk about money. He's taken a lot of money from a lot of people. So not only has he committed crimes, but he's a very, very intelligent individual who has snowed a lot of people, including ones he worked with in his law firm for years. And people are still trying to follow the breadcrumbs to find the things he's done.
Again, I'm going to give the last word there to Thomas More. Again, a member of the Highway Patrol out there in South Carolina, victim of or alleged victim of Alec Murdaugh. I mean, he said it best. Tammy, stand by. We're going to take a break right now. When we come back, McMichaels and Roddy Bryan may have been sentenced for killing Ahmaud Arbery. But the legal wrangling of the case is really far from over. Coming up next, a new motion just filed by the state and what it means. So keep it right here on Court TV. Welcome back to Court TV Live. I'm Michael Ayala. Just days after Greg and Travis McMichael and William Roddy Bryan were sentenced for killing Ahmaud Arbery, a new motion has been filed by prosecutor Linda Dunikoski. Dunikoski made a request for a special condition that the defendants be prohibited from profiting off their experience with the Arbery case. And this is how it played out in court. Take a listen.
The state would ask for a condition imposed along with this sentence, and that is this, that the defendants are not allowed to make any money off of their actions, such as a book deal, a movie deal, social media deal, or anything along any way, shape, or form, make any money off of this experience, this conviction, and this trial. And that should any money be made, that it go into a fund for the Arbery family. And I've had this condition imposed before, and given the nature of this case, we just seek to make sure that, based on their actions, having been found guilty of murder, that they do not then reap some sort of profit or benefit off of their actions via such remuneration to or from anyone in the form of
like I said, book deals, movie deals, consulting fees, or telling their story to someone in exchange for money.
There was a statute on this, but maybe I'm wrong.
There's a Son of Sam statute in other states. I'm not aware of Georgia's. If there is, I assume cite it.
Well, yeah, let's do this. Submit something more formal to the court. I'll go ahead and take a look at it.
Thank you, Your Honor.
And Judge, well, when the court does that, my only concern is how that would impact Mr. Ryan's ability to raise money for his defense, for his appeal. I wouldn't want to be in a situation where he couldn't do that inadvertently because of a sentencing condition.
Yeah, no, I understand the request, but I don't want to just offhandedly grant the request without understanding exactly what the terms are that the court is seeking. So I'd like something in writing from the state explaining what exactly the terms are that the state would be seeking with regard to the condition. And then I guess address that once that's come in more formally with defense counsel.
Per Judge Timothy Walmsley, the man you saw there, per his request, the state officially filed the motion for additional condition of sentence. They also filed a statement of appeal for Greg McMichael, the defense did. Now, this is not an official notice of appeal in the state of Georgia. A defendant has 30 days to file an appeal, and that happens, of course, as I said, within 30 days of the verdict. Still with me, former Department of Justice senior attorney and former federal prosecutor Tammy Allison. What do you make of this request by the state? It's one we see really across the nation. Many states have what they call Son of Sam laws, which I don't know if folks remember. He was a convicted serial killer in New York. He was making money off of book deals, et cetera, et cetera. They wanted to clamp down on that type of thing. Your thoughts on this request by the state?
You know, the state's prosecution, she did a wonderful job laying out all of the evidence against all three of these defendants. The motion is very normal. It's something that we do see in cases such as these, especially because of the high profile nature. And it would be appalling for any one of these individuals to profit from the murder of Ahmaud Arbery. I do typically see these types of motions being made prior to the sentencing hearing as opposed to after the individuals have been sentenced. And it is typically presented in a formal motion where there are citations to statute and case law. As we heard here, the judge would like to see written motion, which would also address the defendant's response that we heard, where, you know, defense counsel, he's worried about how he's going to make his money, how he going to get paid if they can't profit off of this, right? So he would also have to respond to that written motion as a reply. And if the judge allows, the prosecution can respond to the defendant's reply brief based on this isolated issue of, can these defendants profit in any way from anything surrounding this trial in the murder of Ahmaud Arbery?
But I tell you what, Kevin Goff's claims, no matter where you stand on this particular case, they're legitimate claims. I mean, they have a right to, or at least maybe that, I guess that's the question, do they have a right to fundraise or to accept money from folks who want to help them, who may believe that they didn't deserve to be convicted, or just want to help folks who they see in trouble, provide money for their appeal. These things cost tremendous amount of money, or even to pay these attorneys here, maybe they haven't been paid in full. Is that a legitimate concern by Kevin Goff, and should they be allowed to have money brought in that sense?
You know, Michael, I do believe that is a legitimate concern. It's something that the public may not be comfortable hearing, but at the end of the day, these defendants have a constitutional right, just like anyone else, to be able to make money and earn a living. At this point, being convicted of the murder of Ahmaud Arbery and still having appeals and attorney's fees, it's not like they can go work at, Discount Tire, or any other place to make money. They are going to have to figure out a way to make money in other means, even if it's a GoFundMe that's going to pay for their attorney's fees. So I don't ever want to speak about limiting anyone's constitutional rights,
Yeah,
even if they egregiously murdered this innocent, unarmed Black man.
Yeah, fair enough. And I agree with you 100%. Motion practice will begin. The judge will decide the parameters. I will say that from my time in New York, a lot of the Son of Sam claims were overcome by claims of First Amendment violations. So it'll be interesting to see how this all plays out. All right,
Yep.
Tammy, stand by. We're going to take a break right now. When we come back, Theodore Edgecombe is accused of shooting and killing Jason Clearman in September of 2020. In a case of self-defense, should prosecutors be allowed to use the term victim, or is it too prejudicial? We'll hear from our viewers next, so keep it right here on your front row seat to justice.
The word victim is a loaded word. And I think alleged victim is a cousin to it. Now, I hear very capable, responsible, excellent judges who will be telling a story about a case that's ongoing, and they're not talking out of school. I mean, they're not saying anything that wasn't already publicly exhibited in the court, but they'll talk about the victim. And I think you don't even realize that you're putting a very, very loaded term into the discussion.
Judge Bruce Schrader in the Kyle Rittenhouse case was clear. He didn't want the state referring to any of the men killed or injured by Rittenhouse as victims during trial. Yesterday, the judge in our next live trial, Wisconsin versus Theodore Edgecombe, ruled on a similar motion in a self-defense case that he was not going to tell the state how to try its case, presumably allowing them to use the word victim if they so choose. So we asked you, our viewers, in a case of self-defense, should prosecutors be allowed to use the term victim, or is it too prejudicial, as Judge Schrader said? Still with me, former Department of Justice senior attorney and former federal prosecutor Tammy Allison. Tammy, I'm so glad you're with me because I know you've got strong opinions on this one. But let's go to our first comment. It's from Paula Lewis. Paula writes, since he is claiming self-defense, it does seem prejudicial, but what are they supposed to call him? Maybe by name only? No real reasonable answer. All right, Tammy, I want you to ring in on this issue. You know, this is one of those issues that feels like there should be uniformity. It seems to be, you saw it applied one way in Rittenhouse, another way in Edgecombe. Go.
Michael, you already know what I'm about to say. Why are you playing? Now, Edgecombe has a lot more melanin than Kyle Rittenhouse. Now, we both know, okay? So, the fact that this judge here is going to, not let the prosecution, he doesn't want to step on their toes and tell them how to try their case. But in the other trial, the judge was very clear not to refer to people who were murdered by Kyle Rittenhouse as victims. But here, the man with a whole lot of melanin and type 4C hair, he is being allowed in his trial for the prosecution to refer to his, the people that died in his case as victims, So typically we hear the word alleged whenever we're talking about the conduct of the defendant, not alleged victim or victim. The fact that this is even a topic of conversation is strange. It's wild. What?
Yeah, I know. And, it is curious. One of our viewers also wrote to us on Twitter and said that simple answer. Not playing certain cards, but it depends on who's standing trial. That's the reality. There it is right there, at the end of the day. Let's go to one more comment because we're running out of time here. One viewer on YouTube wrote, I think this guy is guilty as sin, but I do like the idea of not using victim because the prosecution should be able to make their case without using too many emotional words or arguments. The prosecution in this case has already said they won't try to introduce 50 pictures of the dead body. Refraining from abusively using the word victim makes sense too. All right, Tammy, you said what you had to say. I agree with you 100%. We're running out of time here. Thank you so much for being on the show. It's always a pleasure to have you. We're going to have you on for this one as well because I know we're going to have a good time with that one. All right, you take it easy. Thanks for being with me. My name is Michael Ayala. Coming up next, closing arguments with Benny Politan.